It's good to see everybody here. So I think we'll begin. Good morning, good afternoon, good evening to everybody from wherever you are. I'm Erin Daly. I'm the director of the Global Network for Human Rights and the Environment, a network of scholars, activists, and lawyers from all over the world whose work lies at the intersection of human rights and environmental protection. I'm delighted to welcome you today to the third in our series of webinars examining human rights strategies in climate change litigation. Before we begin, I want to thank our wonderful panelists for lending their expertise and experience to this rich conversation. And of course, a great thanks goes out to all of you in the audience for joining us today, as well as those who will be seeing the recording. We certainly hope that you enjoy this program. I also want to give a great big thanks to Dave Valet of Widener University Delaware Law School for his tireless support and extraordinary commitment to this effort. Our first webinar in early June featured experts from around the world providing an overview of new trends in climate change litigation in a global context. At the beginning of July, we began our world tour with a visit to Southeast Asia, where we learned about developments in India, Pakistan, Nepal, and elsewhere. The recordings of both of those webinars are now available on our website at gnhre.org, as this one will be soon. And I want you to mark your calendars for our next webinar on September 1st, when we turn our attention to Europe. Today, we're very excited to be in Latin America with a stellar ensemble, including activists, lawyers, and a member of the Inter-American Commission for Human Rights. So let me begin by introducing Maria Antonia Tigre, an extraordinary scholar on environmental justice in the Amazon region, with a recent book out about the Global Pact for the Environment. She is the GNHRE's Regional Director for Latin America, and along with Deputy Regional Director Daniel Noronha, organized this webinar and will moderate it. Daniel will provide translation for Commissioner Soledad Garcia Munoz. Maria, the floor is yours.
Thank you so much, Erin. Good morning, good afternoon, everyone. And thank you very much for joining us in this third installment of GNHRE's webinar series on human rights strategies in climate litigation. This month, as Erin mentioned, we're focusing on Latin America, and we have a wonderful group of regional and international experts to share insights from practice, policy, and scholarly perspectives. Climate litigation has increasingly grown in the past few years as a direct result of the failure of the international community to agree on more stringent climate action from states, and pushing for increased ambition in mitigation commitments or asking states to better adapt to unavoidable consequences of global warming. Plaintiffs have pushed courts to provide a response where the legislature and executive branches have failed. These cases have significantly relied on human rights arguments, a trend that is even more pronounced in Latin America. Latin American courts have reached significant decisions that have questioned the national ambitions on climate change and changed the paradigm of human rights-based climate litigation worldwide. These include decisions or ongoing cases from Argentina, Colombia, Ecuador, Brazil, Chile, and Peru. Additionally, the jurisprudence of the Inter-American system has further helped push countries in the region towards more ambitious commitments and responsibilities towards communities impacted by climate change. But despite growing cases worldwide, there has been a disproportionate attention on climate litigation scholarship towards cases brought in the US and Europe, ignoring the rapidly developing jurisprudence in the global South, which is contributing in innovative ways to transnational climate governance. And while the scholarship focus on the global South is increasing, there's still very limited focus on Latin America specifically. With the goal of broadening the knowledge on cases and trends in human rights-based climate litigation in Latin America, GNHRE decided to host this webinar. As Erin mentioned, we have this wonderful group of speakers. You have their bios on GNHRE's blog on the website, so I won't take too much time introducing them with very long bios, which they're amazing. But we have first Soledad Garcia Munoz, who is the current Special Rapporteur on Economic, Social, and Cultural Environmental Rights from the Inter-American Commission on Human Rights. Then we'll hear from Astrid Puentes Llano, who is the co-executive director of AIDA and has significant experience with public interest litigation, especially in the field of human rights and the environment. The third speaker will be Juan Auz, who is an Ecuadorian attorney and a PhD candidate at the Hertie School in Berlin, where he also collaborates with its Center for Human Rights. And then we have Monica Feria-Tinta, who is a barrister at the Bar of England and Wales and a leading specialist advocate on public international law and climate change justice. So just as a quick technical issue, Soledad will be speaking in Spanish and there will be a translation. So please click there, you will see a button for the translation. You click English or Spanish for whatever, whichever language you want to listen in. And then everyone else will be speaking in English. All right, so Soledad, if you have the floor, you can start.
Thank you very much, Maria Antonia. Well, hello everyone. Thank you very much to the Global Network, Professor Deli and Maria Antonia for receiving me in this space. Thanks also to Daniel Noroña for supporting me in the translation. I thank all of you and those who attended this space in which it is also a pleasure to participate as an academic. So thank you very much. And now I will follow in Spanish to do more diverse, multilingual in this beautiful space. Daniel, cuando tú quieras. En mi presentación voy a abordar cómo el Sistema Interamericano de Derechos Humanos viene protegiendo el medio ambiente y cómo existen al momento estándares que pueden ser perfeccionados para el combate de los efectos del cambio climático. Para empezar, cabe recalcar que el rol del Sistema Interamericano en la protección del ambiente y del derecho al medio ambiente sano viene tomando fuerza en los últimos años desde una perspectiva autónoma del derecho. Sin embargo, el tema ambiental ha estado constantemente presente dentro de la esfera de discusión y debate del sistema desde hace ya tiempo, particularmente en aquellas situaciones que tienen que ver con la protección de los derechos de los pueblos indígenas y originarios en su relación con el sistema para abordar integralmente los asuntos relacionados con la degradación ambiental como el cambio climático. Existen al momento bases normativas y precedentes que permiten brindar un primer marco de discusión sobre el tema. El derecho a un medio ambiente sano está contemplado dentro del artículo 11 del Protocolo de San Salvador, el cual indica claramente dos obligaciones principales para los estados. Por un lado, indica que toda persona tiene derecho a vivir en un medio ambiente sano y a contar con servicios públicos básicos. Además que los estados partes promoverán la protección, preservación y mejoramiento del medio ambiente. Asimismo, la Carta Democrática Interamericana en su preámbulo establece que un medio ambiente sano es indispensable para el desarrollo integral del ser humano, lo que contribuye a la democracia y a la estabilidad política. También, en su artículo 15, sostiene la importancia de la democracia representativa para la preservación y manejo adecuado del medio ambiente, subrayando la necesidad de implementar políticas y estrategias de protección del medio ambiente, respetando los diversos tratados y convenciones para lograr un desarrollo sostenible en beneficio de las futuras generaciones. Del mismo modo, expresiones similares se recogen en la Declaración Americana sobre los Derechos de los Pueblos Indígenas de 2016, concretamente en su artículo 19, en la Carta Social de las Américas, que reconoce el vínculo entre un medio ambiente sano y el desarrollo integral, y hace un llamado a que los estados de la región adopten las medidas necesarias para prevenir y mitigar los problemas de salud relacionados con la contaminación ambiental. Ahora bien, contando con estos elementos normativos, la Comisión y la Corte han venido impulsando una serie de pronunciamientos y resoluciones frente a esta materia desde distintas ópticas. En este sentido, es muy destacable la opinión consultiva 23 del 2017 de la Corte Interamericana de Derechos Humanos. Es esta opinión consultiva hasta el momento el primer pronunciamiento del parte del sistema interamericano que hace un análisis en profundidad sobre las obligaciones de los estados respecto al derecho a un medio ambiente sano en el contexto de los instrumentos del sistema interamericano. La opinión reconoce el derecho a un medio ambiente sano como derecho autónomo por cuanto protege en su finalidad a los distintos componentes del ambiente, tales como bosques, mares, ríos y otros, como intereses jurídicos en sí mismo, aún en ausencia de certeza o evidencia sobre el riesgo a las personas individuales, es decir, una aplicación más amplia del principio precautorio. En sí, la Corte matiza un avance para proteger la naturaleza, no solo por su utilidad o efecto respecto de los seres humanos, sino por su importancia para los demás organismos vivos con quienes se comparte el planeta, al igual que contempla la posibilidad que otros derechos humanos puedan ser vulnerados como consecuencia de daños ambientales también. Asimismo, la opinión realiza un análisis pormenorizado de los elementos constitutivos de este derecho. En ese sentido, indica que el derecho a un medio ambiente sano se divide en dos facetas, una parte sustantiva y otra procedimental. Respecto a lo primero, lo sustantivo del derecho a un medio ambiente sano se relaciona con los puntos mencionados anteriormente sobre la degradación ambiental en sí como una violación a un derecho humano, incluso en la ausencia de certeza científica sobre el mismo. Por otro lado, en lo que se refiere a lo procedimental, la Corte busca dar contenido en el marco de los instrumentos del sistema a la llamada gobernanza ambiental. Esta gobernanza ambiental se refiere a la aplicación de los denominados derechos de acceso contenidos en el principio 10 de la Declaración de Río de Janeiro de 1992 y más recientemente en el Acuerdo de Escazú, que se refiere a los derechos de acceso a la información, participación y justicia en materia ambiental, y que desde el mandato a mi cargo en la Comisión Interamericana de Derechos Humanos también estamos llamando muy activamente a los estados a ratificar por ser un acuerdo ciertamente histórico en el marco de nuestro continente. En ese sentido, el primer precedente donde se desarrolla este aspecto es el caso Claude Reyes contra Chile, de septiembre del 2016, que se refiere a la negativa de las autoridades chilenas de brindar información sobre un proyecto de industrialización forestal, así como a la falta de un recurso adecuado y efectivo para cuestionar la negativa estatal. Más adelante, la Corte también se ha manifestado respecto a este mismo punto, pero en su relación con los derechos de los pueblos indígenas. Al respecto de la sentencia Sanamaca contra Surinam, que en parte se refuerza lo pertinente a la obligación de consulta previa en Sarayaku versus Ecuador, se dijo que los estados tienen la obligación de participar a los pueblos en los beneficios del plan que se realiza en el área. Asimismo, indica que el Estado debe garantizar que no se emitirá ninguna concesión dentro de su territorio, a menos y hasta que entidades independientes y técnicamente capaces, bajo la supervisión del Estado, realicen un estudio previo de impacto social y ambiental que cuente con una amplia participación y procesos de consulta efectivos. Por último, en la sentencia más reciente de la Corte, en el caso Lacajontat, nuestra tierra quiere decir, contra Argentina, la Corte reafirma la autonomía del derecho a un medio ambiente sano y sin embargo aquí realiza un análisis más sucinto sobre la relación de este derecho con la preservación de la identidad cultural de los pueblos indígenas en este contexto. Es decir, se trata de una interpretación de la degradación ambiental a partir de su afectación a los modos de vida de los pueblos indígenas. También la Comisión Interamericana viene impulsando sus esfuerzos para tutelar el medio ambiente en su relación con las personas a través de todos los mecanismos y herramientas que tiene a disposición. En particular, cabe recalcar la creación propia del mandato que tengo a cargo de la Relatoría Especial sobre Derechos Económicos, Sociales, Culturales y Ambientales, que se da después de un fuerte empuje de la sociedad civil de la región para fortalecer precisamente la indivisibilidad en el trabajo de promoción y protección de derechos humanos de la Comisión. Es así que en el 2014 la Comisión toma la decisión de crear la relatoría, que es creada en septiembre del 2017. Quiero decir que entra en funcionamiento en septiembre del 2017, que es la segunda relatoría especial que crea la Comisión en toda su historia. La primera la creó hace 20 algún años para proteger la libertad de expresión y de hecho es una relatoría que trabaja en coordinación con todas las demás relatorías temáticas y de país a cargo de comisionados y comisionadas. Sin embargo, si bien se refuerza la preocupación por parte de la Comisión con la creación de la Redesca, que tiene incluido en su mandato los derechos ambientales, Anteriormente, dentro de los procesos de otorgamiento de medidas cautelares, la Comisión se ha enfocado en la suspensión también de proyectos grandes de infraestructura que afectan derechos humanos, como por ejemplo el caso de Belo Monte en Brasil, o de las 18 comunidades mayas de Zipacapa y San Miguel y Chahuacán sobre la construcción de hidroeléctricas, y también habiendo instado a Guatemala a suspender la concesión del proyecto minero Marlín. Asimismo, se encuentran los hechos respecto al pueblo indígena Nobe, en las que se solicitó al Estado de Panamá suspender la aprobación de la construcción de usinas hidroeléctricas en el río Changuinola, lo cual conllevaría la inundación de parte del territorio de las comunidades. Sin embargo, desde la instalación de la relatoría se han emitido un par de medidas que invitan a una nueva posibilidad de análisis sobre cómo los elementos de gravedad, urgencia e irreparabilidad se complementan en el ámbito ambiental. Tal es el caso, por ejemplo, del caso del río Mesapa, donde la Comisión, en relación con Honduras, donde la Comisión consideró el grado alto de contaminación que presentaba el río como parte de los argumentos que completaba el requisito de gravedad de la solicitud. Es muy importante también este precedente porque por primera vez desde la creación de la relatoría se contempla también como gravemente expuesto el derecho a la salud, no solamente la vida y la integridad. De igual manera, más reciente se encuentra la medida otorgada a favor de los habitantes, de las personas habitantes del río Santiago, en el estado de Jalisco, de México, también por afectación a su salud, vida e integridad en relación con la contaminación y falta de supervisión por parte del Estado de las actividades industriales que ahí se realizan. No obstante, respecto al sistema de peticiones y casos, todavía no existe un antecedente que se haya tramitado con éxito ante la Comisión que aborde estos temas. Sin embargo, existe una inadmisibilidad en el caso del Parque Natural Metropolitano de Panamá, que fue inadmitido por falta de legitimidad activa, donde la Comisión indicó que no se determinaban los afectados directos por parecerse a una acción popularis, y la segunda por falta de nexo causal respecto a las acciones específicas de los estados en su relación con el calentamiento global, como fue la inadmisión del reclamo de las poblaciones inuit del Círculo Polar Ártico contra Estados Unidos. Por su parte, desde los distintos mecanismos de monitoreo, la Comisión y su Redesca venimos realizando una actividad más intensa para ir incorporando elementos relacionados con la protección del medio ambiente. En esa línea, que primero el informe anual de la relatoría se han incorporado una sección dentro de los monitoreos de los países dedicados al medio ambiente y a los efectos del cambio climático. Asimismo, en el informe anual de la Comisión, en su capítulo 4A, se agrega también un abordaje sobre las medidas que los estados están tomando en relación con la protección de este derecho, en particular en el informe anual del año 2018. Y cabe recalcar también el informe que se hizo público en 2015 junto al informe anual sobre el derecho humano al agua. Por último, desde una perspectiva enfocada exclusivamente sobre el cambio climático, en el desarrollo de sus audiencias temáticas, se ha tratado el tema en dos ocasiones específicas, por un lado, en el 2005, en relación con el caso respecto a la solicitud del pueblo inuit contra Canadá, se realizó una audiencia sobre calentamiento global y derechos humanos. No obstante, recién para el 173 periodo de sesiones, ya creada esta relatoría especial, la Comisión aceptó una solicitud presentada por organizaciones de la sociedad civil que se refiere a los efectos del cambio climático en los DESCA, de niños, niñas, adolescentes, mujeres, pueblos indígenas y otras poblaciones en situación de vulnerabilidad en la región. En base a estas consideraciones, el sistema interamericano se está convirtiendo en un foro de importancia para la protección del medio ambiente y además están empezando a generar estándares en la materia. De esta manera también la Redesca, que tiene encargado por el plan estratégico de la Comisión la elaboración de estándares en materia de protección del medio ambiente y concretamente en materia de cambio climático, estamos buscando actualizar los contenidos del derecho para que tenga consonancia con la realidad de la región, cuando al menos 16 estados del continente lo incluyen en sus constituciones, el reconocimiento del derecho a un medio ambiente sano, y en esa medida, además de reconocer la afectación del cambio climático en la biosfera y en distintos ecosistemas, los efectos transversales e interseccionales que esta crisis trae para la región será conocidos por la región, por la Comisión, disculpen, de manera inevitable. Y por tales motivos, que a través de la Redesca seguimos promoviendo esfuerzos y de hecho ahora estamos con varios proyectos en curso para asegurar que el Sistema Interamericano de Derechos Humanos, en concreto la Comisión, aborda esta temática de una manera más directa, tomando en consideración las lecciones ya aprendidas a partir de la presente crisis de la pandemia, que también pone a prueba la fortaleza del sistema y de los estándares del mismo para proteger los derechos humanos y concretamente el derecho al medio ambiente. Y en tal sentido, solamente decir que estamos trabajando muy activamente desde el mandato en el contexto de la pandemia por hacer que el foco también de las acciones de los estados americanos tenga muy en cuenta tanto el derecho a la salud como otros derechos económicos, sociales, culturales y ambientales, y particularmente también el medio ambiente. Porque como muchos pueblos indígenas nos están recordando estos días, no es momento de ser románticos y pensar que debido a las cuarentenas el medio ambiente no está sufriendo. El medio ambiente sigue sufriendo mucho en toda nuestra región y por eso que desde nuestro mandato especial y con este tema finalmente incluido explícitamente, vamos a seguir trabajando con también, por supuesto, la Global Network y todas las personas que acompañan este panel, a quienes también estoy deseando escuchar. Muchísimas gracias por su atención y thank you very much to Daniel for the translation.
Thank you very much, Soledad. Juan?
Hi. Good morning, good evening, good afternoon, everybody. I'm Juan from Ecuador, and I'm going to try to focus on the overview of all this panorama vision of what, to me, entails human rights-based climate litigation. First of all, just to clarify or to methodologically point out some remarks, I'm going to be when I refer to Latin America in my presentation, I'm going to mainly address 20 countries, and those countries that have some civil law legal tradition, and those countries that are parties to the American Convention on Human Rights. Why am I doing this? Because that's part of my methodology as well in my research. Second point I want to clarify is that when I'm talking about human rights-based climate litigation, I'm talking about litigation that resorts to human rights from the part of the plaintiffs or the applicants, and also on the part of the judges in the rulings. Having said that, I want to start by pointing out the relevance of focusing on Latin America as a region when we're discussing this issue. I think that Latin America is a very important and interesting region to focus our attention on, and particularly this issue, because we're talking about climate justice in the end of the day. We're talking about how climate-related impacts are affecting and will continue to affect the enjoyment of the human rights of everybody, especially vulnerable and historically marginalized populations in the region. And we have, Latin America, we have several commonalities there that definitely plays a role in the ways in which we should approach and analyze this question. So we have a common history. We have a common history of colonialism, of dictatorships, of coming back to the rule of law after the dictatorships. We have constitutions that whose approach and design are very much similar. We have plurality of also of languages, of traditions, of cultures, especially when it comes to indigenous peoples and people coming from African backgrounds. But also we have a very rich environmental heritage. So the richness of our ecosystems are pretty much one of the reasons why as humanity we're not yet doomed. And therefore, we should definitely, as an ethical mandate, protect those. Unfortunately, on the other hand, we also have a vast history of inequality in the region, and that definitely should play a role in our analysis. Talk about, first of all, what are the main opportunities for this litigation to unfold in the region, and what might be the barriers, the potential obstacles for this to happen? So just to start with, when it comes to opportunities, I want to focus mainly on the constitutional side of things. I think that when we address human rights-based litigation in Latin America, we have to bear in mind that we are not approaching the same type of litigation as in other parts of the world are doing, especially in the global north. So in the global north, we see a surge of litigation that relies heavily on statutory grounds, and very few of them are actually based on human rights claims, even though those human rights-based climate litigation cases that we've seen in the past have become very popular and very landmark cases. When we talk about what happened now with the case in Ireland, what happened with the case in Uganda, and so on. But those are the outliers in the global north. When we talk about climate litigation in the global south, specifically in Latin America, some scholars have pointed out, we are always going to rely, especially in constitutional rights claims. And that is very important for us to acknowledge. Most of the cases that I've seen that have human rights arguments within them, they raise a constitutional argument. So in that sense, I want to address three aspects of constitutional law that to me are very important when we analyze these types of cases. First of all, the fact that all constitutions in these countries that I mentioned in Latin America recognize the right to a healthy environment, which has been brought as the core element of argumentation in all of these cases. Not only, of course, more recently on climate-related cases, but also on traditional environmental-related cases. Also, there's an openness in all the constitutions about or concerning international law as an element, or as also a piece of law that judges should address or should analyze as well as part of the domestic law. And thirdly, there's this, to me, this fantastic constitutional tool, which is the amparo tool. It's this type of constitutional proceedings that seek some sort of injunction relief that is very much present in all of the constitutions in our region. And according to the survey that I've conducted, it has been used almost every time when we talk about human rights-based climate litigation. So moving on, climate litigation is definitely one of many of the plethora of mobilization strategies that environmental movements are using in the region. Just to be clear, it's just one of them. And NGOs, environmental movements, and so on are consistently resorting to the courts to demand the protection of key ecosystems that support them, and thereby are shaping what has been coined by some scholars as the global judicialization of environmental disputes. So obviously, this constant push towards a more ambitious and progressive reinterpretation of legal frameworks and the cross-fertilization of knowledge in legal epistemic communities would not have an effect without the reaction of judges in the region, who have been instrumental in converging the interests of litigants into their decisions, thereby expanding some forms of judicial activism. So in the region, we've seen how procedural and substantive rights related to the protection of the environment, or so-called environmental rights, appeared in the contested process of incorporating them in new constitutional reforms in Latin America. So that's something that we see today. As I said, that 20 countries in the world recognize, in the region recognize this right. And at the same time, courts, since the very early, since in the early 90s, they have started to interpret what this right actually means. So we've seen cases of environmental related disputes in Argentina, Colombia, Costa Rica, Paraguay, Mexico, and so on how courts are actually interpreting this right under the light of the facts of a given case. So we can see, we can claim that this environmental, let's say, legal framework is a dedicated one, according to a category from some scholars. However, that we cannot say the same for climate-related law, because not all of the countries in the region have enshrined legislation or specific legislation related to climate change protection or to climate protection, even though all of the countries in the region are parties to the UNFCCC and the Paris Agreement, and they are also working towards the construction of their NDCs and submitting them to the Secretariat. Now, one solid point of reference in the regional legal landscape that provides an important advantage for litigants when it comes to human rights-based climate litigation, as I said, is the openness of the domestic legal system to international human rights law. So this presupposes that judges are actually integrating international standards into their own rulings. Some, let's say, idiosyncratic doctrines, such as the bluff of constitutionality or the conventionality control. We can see this at a very, an early example of this application of international environmental and human rights law in domestic law in the Monroy Céspedes versus Municipio de Villavicencio case, where the Colombian Constitutional Court established the linkage between the environment and the right to life and personal integrity by interpreting the Stockholm Declaration, the International Covenant on Economic, Social, and Cultural Rights, and it asserted that the environment is a fundamental right for the existence of humanity. And that was, of course, an amparo injunction, type of injunction. More recently, since, of course, since 2002, we have adopted the Escazú Agreement, as everybody here knows. It's very interesting that despite not being a ratified treaty yet, on July 3rd, 2019, the Argentina's Federal Contentious Administrative Court issued a judgment that invokes for the first time the Escazú Agreement to emphasize the importance of the right to access to information on environmental matters. This is the case, the FARC is an Argentinian NGO versus YPF in the context of the Vaca Muerta oil and gas field project. And obviously, I'm not going to touch again on the importance of this aspect of constitutional design when it comes to the Inter-American Human Rights Standards, because that was very much clarified by Soledad. So, of course, we have other types of cases. More recent cases. We've all heard about the case that came out in 2018. It was a tutela, obviously, another form of amparo that was lodged by 25 young children and youth, but with the help of the NGO De Justicia, where the applicants argued that deforestation in the Amazon region caused climate change. And of course, in this case, the Supreme Court of Justice agreed. In a very similar case, IDL, the Instituto de Defensa Legal, filed an amparo with very similar arguments as the De Justicia one, invoking also international law as their main arguments. The recent case of the 5 young Argentinians filed last month, together with 2 environmental NGOs before the Argentinian Supreme Court of Justice, again, was an environmental amparo. And applicants argued that the provinces of Entre Rios, Santa Fe, and Buenos Aires, and the municipality of the city of Victoria are in breach of their joint duties to protect the Paraná Delta's wetlands and thereby preventing environmental harm with transboundary effects. So of course, these cases are pending. And in this case, for example, the applicants invoked the Convention on the Rights of the Child, the Convention on Biological Diversity, the UNFCCC, and the Paris Agreement. So we see this pattern of cases that are not entirely related to climate change directly, but are touching upon. Just to finish, I just want to point out to some of the barriers that, or the structural barriers that I see, and is, you know, basically can be summarized in one word. It's basically the extractivist or extractivist economy, and how all of our countries in Latin America are pretty much tied to an extractive economy that renders the activism and filing these cases very, very difficult and even dangerous. We've all seen the last Global Witness report on how many environmental defenders from Latin America especially are being killed because of their work towards defending the environment. But also we've seen how the presidential design of democracy in our regions somehow is filtering the work of judges in the region. That's why the rule of law is very important when we analyze these type of cases. And that's definitely a barrier that we should also consider when we talk about this. I think that's for me. Sorry for being super to the point and very, very, very fast with my approach, but thank you very much.
Thank you very much, Juan. Astrid, you're up next.
Thank you very much, Maria Antonia, Erin, for the invitation. It's really an honor for me and for Aida to be here and contribute with our experience. It's a very complex theme, as you know, and it's really wonderful that you decided to include Latin America in this series as one of the regions to look at thinking about climate litigation and human rights, because as you just heard, there's a lot of things happening in Latin America regarding climate litigation, specifically linked to human rights. And thinking about the time and the importance to talk about this, I want to share and highlight a message that probably we that have been at law school and working on this for a few years have in mind and were taught, etc. But sometimes it's the emphasis is forgotten, and is the fact that the law and the legal decisions and regulations, etc., are really a tool, and that we are all working towards is justice, and that should be the objective. So thinking about the climate crisis, where we're really thinking about, and the objective and the goal of all of this litigation, as it was mentioned before, it should be climate justice. And why it is important today to mention that specifically in Latin America, because as you heard, we already have a lot of laws, constitutions, and guidelines, but unfortunately the reality is very different from those decisions. And that is the main challenge that we are facing today in the region, because the increasing litigation speaks in a large part of what the people need and what communities need. I'm talking from my personal experience, and also AIDA. We are a regional organization working in Latin America for over 20 years, using the law, specifically international law, to protect the environment and human rights. And one key thing that we have seen is that while we have all of these decisions and constitutions, the reality is still different. So I want to highlight why this is important in Latin America, and a few things were already said, but just to have in mind, because this is where we are litigating, and these facts talk about who is bringing litigations to the judicial systems, to the courts, even to the Inter-American Court and Commission. So Latin America, as it was mentioned, it is the most unequal region worldwide. And this is a conclusion from all studies that have been done about inequality, including the World Bank, the UN Economic Commission for Latin America, universities, Oxfam, etc. So we live in a region where the differences between the people with more wealth or power, economic or political power, is larger than the ones that do not have. And this is important because it's not only showing the impacts on climate change already, but also on access to justice, and we see that every day. It's also Latin America, the most dangerous region in the world. And Juan mentioned the report that was released recently from Global Witness. And again, it's the same conclusion that over and over we see. And so that is a key element also, because we are litigating not only for the climate justice, but literally for life. And several people, leaders of communities and movements, are putting their lives under fire because of this work. And unfortunately, I mean, we work with a lot of the leaders, and one of the things that we all have had to work on also is strengthening the protection of the people. And this is definitely an element that we have to have in mind. The other element is that Latin America is also a very diverse region from the biodiversity perspective, but definitely from social and cultural perspective. There are over 800 indigenous and ethnic groups in the region, which means that we have reached a lot of diversity and knowledge and different perspectives that can be used, and that if we're not protecting effectively in terms of the rights and the territory, that diversity and the knowledge is being lost. The other thing also is that Latin America is a very vulnerable region for the climate crisis. It's maybe not the most vulnerable, but it's very vulnerable, and we already are seeing the impact and suffering the impacts from the climate crisis. And it goes from the droughts in Central America to the fires in the Amazon that each year are worse. And we also are seeing that huge impact on human rights, seeing, for example, thousands of migrants going from Central America and looking for asylum in the US because of the link of climate change. 80% of the crops in Honduras in 2018 were lost because of climate change. And then we saw at the end of that year and in 2019, thousands of people fleeing to the US because of the loss of their crops. So this is already happening in the region. And we also have this world that I'm not going to use a lot of time on it, with constitutions and good decisions from the courts and treaties that have been ratified. So what's the challenge here for us, basically, from the human rights and the climate movement and the people that, like us, that work as attorneys and using the law? The challenge here, as Soledad also mentioned, is to make sure that law is actually working to change reality in the time and the form that we need. And that is not happening in the region. We are seeing also the climate laws, the climate commitments are very far from what we need to be, that we are not seeing responsibility, that we're not seeing accountability, not only from governments, but also from state actors. And that is the objective of the litigation today. People, and us included, organizations, community, we are using litigation because the executive branch and the legislative branch are not doing their job. And that is a key element and a key role that we need the judiciary and the courts and even the inter-American system to understand and have this historic role, really, to make a difference in the region. And of course, the challenge there is the time, the time in which we are working, the time that we're challenged, because as it was said in other webinars here, unfortunately today, the world already has warmed 1 degree. The trajectory that we're going will probably put us on 3 or 4 degrees of warming, which is terrible for the environment and terrible for the people, specifically for the most vulnerable. So what we need is to implement actions as fast as possible that are benefiting the people. And I want to share with you a story about what is that I'm talking about. So I'm Colombian and I studied in Colombia. I live currently in Mexico for the last 17 years. And in AIDA, we have been working for over a decade with a community in Colombia that is trying to protect the páramo in Santurban. Santurban, in general, páramos are key high mountain ecosystems that are known as factories of water because of the importance to the fresh water. And the páramos are also key for biodiversity and climate change. So we started working on this situation where the community called for our support because there was a concession to a company to implement open pit mining in the Paramo that will be devastating for the ecosystem. And it was going to be a pilot project that it was the open or the window for a large investment, even with the World Bank and other foreign investment to implement mining in the Paramos. Colombia has 70% of the Paramos, so as you can, in the Andean region. So as you can imagine, it was a very important case. So we decided to start working on this for over a decade now. And we got that for the first time ever, the Ministry of the Environment denied the environmental license. After a long legal fight, the community brought the claim to the IFC, that is the International Financial Corporation. So it's a private branch that invested in this project. They're linked with the World Bank. The community brought the claim there. The World Bank decided to withdraw the investment. There has been more than several decisions from different courts in Colombia to protect Paramos. And yet, literally today, there is a concession now with a fourth company over the Paramo that is trying to be implemented. And here the argument is that the concession is actually outside of the line that delimited the Paramo. And so what I'm trying to say here is that even with the decisions from the highest courts in Colombia, even with the first decision in Colombia that declared that climate change was important and that it was an obligation of the state to protect Paramos because of climate change, that is a decision that was rendered in 2016, we are still not seeing the results that we need. And the community is still trying. And now there's a national movement trying to protect the Paramos because now it turns to be like a procedural conversation about where is the concession in terms of the map, instead of thinking from the principles and the perspective that a mine in that region is impacting the ecosystem and thus will be producing all of these impacts that we are trying to avoid. So this example links to what I'm trying to say and what we have, the biggest challenge that we have. And what I wanted to share with you today is that we definitely have the legal tools. We really have, sometimes it's hard, but we have judges that are open to it or even open to learn about this because we know that it's very complex. There is communities and movements working on this, that if we are litigating is because that is the last resort. We don't have time, we don't have anything else, and the laws, the plans, the programs are really not going fast enough. And unfortunately, in some cases, especially after the pandemic, we're seeing really worrisome backwards on policies. And so that may become more litigation. But what we need to make happen, and this is a key role from us as attorneys and judges and the commission and the movements, and to work together with scientists, with communicators, so that these decisions and these principles, the laws and the obligations will actually mean what we need in the region, in the territories, in the communities, and by the way, in the cities where most of us live. 80% of the population in Latin America live in cities. So it's not only about the indigenous peoples and the local communities, that is definitely important as well, but it's also about how we all are living and how we are going to live in the future. So this is a key thing that we are seeing in development. It's very interesting to see a lot of the decisions coming. And again, I think that the big challenge there is make sure that the litigation is online with the climate justice objective that we need, and that the beneficiaries will receive that participate, because we're not talking about people as victims. The communities and the more than 800 indigenous and local communities, tribal communities that I mentioned, they're not victims. They are suffering the impacts, but there's a lot of knowledge there that, by the way, has a lot of solutions for us to see how to be resilient, how to find alternatives to this extractive model that is and has us as we are today. So I want to stop there because I know that part of the key thing, and of course I would love to hear Monica and then exchange ideas. And thank you for this space, and I'm looking forward to continue the conversation.
Thank you very much, Astrid. Monica?
I'm delighted to be here. Thank you so much for the invitation. I'd like to divide my intervention in three parts. First, I'd like to give some preliminary remarks. Second, I'd like to address a couple of substantive issues concerning Latin America, and a little bit following from the discussion that my colleagues have already started. And finally, give a couple of conclusions as to where what are the points to watch in this type of climate change litigation. So on the preliminary points, I have 3 points to make. First of all, I do not think that climate change litigation can be put in compartments by regions, because it's against the very essence of what climate change harm is about, which is transboundary. Basically, what is happening in Honduras, you know, as Astrid was describing, it's not necessarily caused by agencies acting in the region. It is more complex than that. So when we are looking at possible actions, then the panorama is far more complex, and the actors are also more diverse. So that is, I think, quite interesting. And I will give you one example as to in what way I mean so. Recently, I was involved in the Cerrejón case, which is a case that is very well known. It is the largest open pit mine in Latin America, and one of the largest in the world. Now, so you can see this as just a Colombian problem or Latin American issue, but it's not, because once I started working in the case, I realized that actually the big question was who benefits from having that mine in Colombia. So the mine operates in La Guajira, in the north part of Colombia, which is the second largest, poorest region in that state. So I followed the call, and basically the thing was that the call was being sold from an office in Ireland, CMC, sold some call to Ireland itself, to a state-owned company, but most importantly, the call was marketed and sold to the rest of Europe and perhaps other parts of the world, but centrally Europe, among them Germany, Netherlands, and perhaps Turkey. So once the panorama was there, I helped to devise a strategy. And what it appeared key was that it was not enough to go after the state, although it is obviously relevant to seek to identify the obligations of the state, but really to go farther than that. And Astrid was mentioning the private sector, and I think that is also quite important when developing strategies. And here I identified the 3 owners of the mine and decided to advise on an action, legal action that could actually bring them into the picture and address the obligations that these companies also had. So now it is a very sophisticated strategy, but hopefully it is a way to put an end to what has been going on there for many years. And that's one of the examples where, which in a way talks about these limitations that sometimes there are concerning specific jurisdictions where you may have a beautifully drafted constitutional court decision, but that couldn't be enforced And it was for months, just written word, and nothing was happening. And why? Because I think that on that preliminary issue, basically, we cannot just contain the climate change issue to the region, or to, let's say, in this case, Colombia, but you have to go after the real decision makers. You have to go after those who hold the power between doing this or doing that. One of the things that happened immediately when we filed the case was that a newspaper from Australia covered the news. And that's the best example how climate change litigation is not about, separate regions. So they covered the news. The first thing that actually they were interested about was about what BHP, one of the companies that owns Cerrejón mine, had to say about the human rights violations we had depicted so well in a special legal action brought before the UN, in particular before the special procedures. And that was interesting because 2 days or something like that later, after a TV program was aired, we had actually BHP announced that JP Morgan had been contracted to actually look into the possibilities to sell the investment that they had in Cerrejón, because the investors, particularly the biggest one, was not happy with the association with a mine that was violating human rights. So, I mean, I have to throw in this example as to show you how complex the whole issue is, and in what way it's not enough to go to state obligations, but there are many, I would say, interlinked issues with private actors' obligations and companies. And, in reality, it is about pinning down those who are contributing most to this type of crisis and see how best we can get a reaction from those, accountability from those actors. Secondly, as a general comment, I like to say that we should stop seeing, and some commentary that I have seen around tend to see as divided between here we have domestic systems and there we have international law. I think that type of parallel worlds is very wrong. That is not the case in practice, certainly not in the practice I am aware of. What really has been happening is that there is a constant interaction, and as an advocate, I have used the potentials that both systems bring and the connections and how they actually somehow co-opt each other, wanting to apply the laws that are relevant, and also using the mechanisms in a way that one helps the other. So I'll give an example later on that. Third, I like to actually make the point that the Inter-American as a region, the whole system has brought very important developments. I think that is quite, I guess, from a comparative point of view, interesting to notice that whereas in the Inter-American approach to the whole issue of the right to a healthy environment, we have looked at that from the right to life kind of gateway. When we speak about the European region and some of these developments in climate change litigation that have already, that are quite advanced, have taken place in Europe. In the European context, the gateway to environmental law type of claims have been via the right to privacy provision under the European Convention on Human Rights. So in that sense, Juan, I disagree a little bit with you when talking about, Latin America tending to use constitutions as ways to get legal frameworks for domestic claims, and then you have the rest of the world that have been mostly driven by a statutory type of legislation, because say in Europe, yes, it may have been like in a statutory law as a way to get cause of action, but ultimately the European Convention on Human Rights has been of great use in the type of climate change litigation we are seeing right now, and certainly the Urgenda case is one example of that. So I would say that actually the Urgenda case is an interesting example to see to what extent now is shifting the whole thing. And it's not just the right to privacy when it comes to the European Convention, but actually they have learned from developments in the inter-American system when it comes to the importance, how do we construe the right to life, and how is that applied in the context of the Paris Agreement, in the context of climate change litigation. To finish with that, I like to say that I am counsel on one case which is right now pending before the UN system, before the UN Human Rights Committee. And there I am bringing a lot of arguments that come from the Inter-American region that are extremely developed when it comes to the understanding of duties on the part of states in relation to harm that comes as a result of climate change. And it would be interesting to see now how the UN engages with those arguments. But having given those general submissions, I like now to turn to a couple of substantive points. It was mentioned earlier that the advisory opinion on environment and human rights was an important development in the Inter-American system. I like to say that for me, in fact, it's quite remarkable the impact. Hello, can you hear me all, or is it? Yes, sorry. It's quite remarkable the impact of the advisory opinion because, and for those who are curious, I published a very old article on justiciability on economic, social, and cultural rights, analyzing all the Inter-American system and a number of cases. And we are talking about cases that this was about 10 years ago almost, and it followed all the decisions back then. So with that background knowledge of what happened back then and how important developments were already taking place, I'm not surprised that we had an advisory opinion of this sort. But what really the advisory opinion did was it constitutionalized environmental law as part of human rights, something that had not happened before in any system. So as a general international law specialist, I can tell you that what we had when it came to areas of international law was we had on the one hand human rights, and on the other hand divided and coming quite late in the development of international law, environmental law. And whereas human rights were rights based on, if you want, hard rights, on the other hand, environmental law was very much principles and soft law, up to the point where now the world has started to waken up from that situation. And I think the very starting point has been the advisory opinion number 23, which is not isolated because there has been other important decisions, particularly in, for example, before the International Tribunal for the Law of the Sea, which already dealt with very important notions of environmental law in relation to the sea, but nevertheless, which has been mirrored quite well in the advisory opinion number 23. So there we have the right to a healthy environment. But what is the relevance right now of that? I mean, we heard earlier about the state of litigation before the Inter-American system. I must say I was quite frustrated when I read the Inuit case, in particular because I thought it was a very well drafted complaint, over 100 pages long, and the commission didn't even register that back then because it was argued that it was not clear what the commissions and omissions of the state had been for that situation to exist. And I think that it was in a way a very poor comment because it was almost, you know, deciding on substance without really even admitting the case. So it was a lost opportunity to actually dealing with climate change directly, straightforwardly, climate change arguments and the American and the rights in the inter-American system. Now, yes, we have moved somehow now into a new case law that is embracing the advisory opinions perspective. But I think that advisory opinion opens a possibility to have a case like the one I am arguing before the UN, which is, you know, squarely on climate change and actually seeking measures that can help mitigation and also adaptation, and that is required from the state, and to actually use the Paris Agreement as a source, a treaty source to interpret also the obligations under the American Convention. And I think the jurisprudence of the court has already prepared the way for interpreting any treaty that is relevant to the relationships between the parties. And so the way is out there, but let's see what happens next. We certainly need perhaps good test cases to be able to move now that we have such a good grounding with the advisory opinion. Now, it's been commented before on what is going on, however, at domestic level. So we have the wonderful situation that in Latin America, systems are monist, meaning that international law can be directly invocable in the domestic system. And that has been my experience, and that is why, although I am a English barrister, I have been invited to argue cases before different jurisdictions in Latin America, and they are Colombia, Ecuador, and Mexico more recently, with actually arguing international law from my own expertise to assist the court to interpret international law and see the relevance of international law in construing their own laws. Sometimes this is not necessarily only via the constitutional law gate. Sometimes it is administrative law, which is at debate. So sometimes the cases come in all sorts of shapes because you don't know how procedurally may actually get there. But what is important, and I think an advantage of Latin America, is that possibility to have international law being applicable directly. And it is not idiosyncratic, it's just that these are monist systems. Whereas in, obviously, say like in a jurisdiction like the UK, we do need enabling legislation. So it's not enough that the UK has signed and ratified a treaty in order to be able to apply that. There is a need for enabling legislation in order to make that justiciable before a court. So we have great tools in Latin America in that sense. So one example of a recent case where that has been, where that happened, perhaps I give two examples. One was the recent case before the Supreme Administrative Court in Colombia concerning the Sierra Nevada, the Santa Marta case, which raised not only issues concerning the indigenous peoples' entitlements, but also the rights, the obligations that Colombia had under the Paris Agreement, and also under the 1992 Convention on biodiversity. And that's quite a powerful tool together with other principles of environmental law. In the case of Ecuador, obviously, we have the wonderful constitution, but also I'd say just the beginning of understanding how international law, how that's not just about the constitution, but how international law also make this binding on Ecuador, let's say, to protect a natural world where there may not be indigenous people. So then there's no question as to whether there is a right to consultation or not, because there's simply nobody living there. So you actually use this type of pure, arguments on the right to nature to be able to seek the enforcement, the respect of this constitutional court provision, but also of the principles enshrined in these international conventions. Finally, I like perhaps to make the point that although in the Inter-American system there has been a lot of good and positive developments, nevertheless, it is quite worrisome the fact that action perhaps is quite slow. And here I give the example of La Roya case. La Roya case was a case that took about 10 years to actually get to the point where the commission could actually look into the merits. So that kind of, work is going to be very slow. And the question is, do we have that time? I would say probably not. Right, it is very time consuming. It is very, very hard to push a case like that. I don't know, probably at least Astrid must attest to that. I have litigated cases from beginning to end, and I can tell you that is not very welcome when a case takes over 10 years just to get to the first phase. And you can expect some more years later before the court to get a decision. So although principles and substantive law is developing, and principles and substantive law in the both constitutionally in the domestic systems and also in the Inter-American system are now quite developed and good, and they are already colonizing, if you want, other systems, including the European system, and I would say now the law under the UN. Nevertheless, we have the challenge in Latin America as to procedurally where we are. And these are the two conclusions I perhaps like to leave there for discussion. I'd say that there are two main challenges for us. And one is the procedural aspects of all this type of litigation and how fast can go. And how best to approach a particular case to make sure that you are using the best possible procedural tool to get where you want to get, a fast result. I'll give you one example. With the UN system, the UN was reacting very slow in this Torres Strait Islanders case against Australia. The islands are sinking, and what they were asking basically was measures of immediate action to build seawalls, and on the other hand, a number of measures for mitigation. They want Australia to have the right policies. Now, we filed this, let's say, in April, and what happened by December? So I knew that the case before the UN was going to last a little while. Unfortunately, it's an average of 3 years. Provisional measures in that context would be tough and something not really welcome because it's a rather conservative system. Now, however, the way it was argued somehow prompted that Australia wanted to react, maybe in a defensive way, but what they basically did was to allocate a certain amount of money, quite high amount, for measures to actually build the seawalls. And this was announced in December. So between April and December, we had that, which was not acknowledged by them as a measure directly because of the case, but that was the only reason why they did it. So sometimes, procedurally speaking, one is going to have to be extremely experienced in how different mechanisms react to different things in order to devise the best strategy to follow and where to go as well, because different organs react in different ways. Now, second, in addition to the issue of procedure and how we need a better reaction, and this goes as a critic, to all the systems, including the Inter-American system. I'll say that the second main challenge is enforcement. Enforcement, because there's a number of wonderful decisions, and we have heard some of them. But I think the key challenge there is, how long does it take for the state to actually implement this type of decisions? And that's why working on a from a perspective that not just looks at the state, but also looks at private sector in combination is quite important, because one is not likely to get only the state reaction, but one needs, you know, the other support. In the case, for example, of Cerrejón, what I was mentioning before, it was quite important for us to see what was going to be the next step after that. And I am hoping that we are going to have the right type of pressure, because the end goal is, you know, the closure of that mine. I mean, Colombia is a party to the Paris Agreement. Ireland and Germany, Germany is no longer doing coal mining. So why is it that the electricity of Germany is paid at the cost of, you know, indigenous peoples dying in La Guajira? I mean, what type of society we are, that we are very clean and green in Europe and we are heading towards that, but, you know, we are buying our electricity, or we are still relying on dirty coal, which is produced, you know, in areas like the one I just mentioned. I think that's just unacceptable. And I think at least in this particular case I worked on, I thought it was genocide by the back door, because it has been happening for a very sustained period of time. And the type of impact, like finishing with the water sources, because all goes into the intensive efforts of actually extraction of coal, diversion of rivers, diversion of important water resources for the whole population, affecting the food security, because if there is no water, the old kind of resources that the communities have, for example, the guanaro tree has almost disappeared, wiped out. So people are suffering from thirst.
Sorry, we're running a little bit over time. So if you can just finish in 1 minute.
Yes. So these are kind of urgent issues that we cannot possibly leave it to, you know, to a very long procedure. So I like to leave you with those thoughts, and I will be very happy to engage in questions and answers. Thank you.
Thank you. Thank you very much to this wonderful panel. It was really interesting to hear all of you in the different perspectives here. I just wanted, we are running over time a little bit, so I just wanted to ask a few questions that came from our participants. And if you can please just answer them as well quickly, even though some of them are more require a little bit more insight. But the first question is for Juan, and someone asked how the Escazú agreement could benefit the use of climate litigation in Latin America. Yeah. You can go ahead.
Thank you very much. So as soon as the Escazú agreement is ratified, I think we need 2 or 3 more states to actually ratify or send their ratification process to the Secretariat. It's definitely the case that that is going to be useful for climate litigation. As we've seen in some of the examples that I already mentioned before, in some of environmental or human rights-based environmental litigation and some of the, let's see, early climate change litigation as well in Latin America, both plaintiffs and judges are resorting to some of the international instruments to build up their arguments and to make sure that some of the standards that are there in international law can be compatible with the facts of a given case. So, and we just saw how, you know, this case in Argentina, for example, even though the Escazú agreement is not ratified, the judge agreed that those standards are still valid and important for the state of Argentina to take into consideration. So, and at the same time, all of these treaties, even though, I mean, there's more, there's a use beyond the direct application of a treaty. Many of the international treaties are also interpretative tools for adjudicators and for litigants. So regardless of the treaty, of the content of the treaty, I think that fortunately enough, the constitutional design of most of our constitutions in Latin America allow this this openness to international law. So I think that is going to be very useful, especially considering that procedural human rights, environmental rights are going to be, in my opinion, one of the main concerns when it comes to litigation in the future.
Thank you very much. And we have two questions for Soledad. The first one is on the rights of nature, which was mentioned in the advisory opinion and the Lackawanna case. So I was wondering how we can help push climate litigation forward in the inter-American system. And the second question, since you mentioned the pandemic and the effects of that, someone also asked about the precautionary measures on the protection of indigenous communities during the pandemic in Brazil and how it relates to environmental rights as well from those indigenous communities, the lack of action from the Brazilian government there.
Yes, thank you very much for the question. Really relevant, both of them, and in relation to the right to nature, I think this is one of the opportunity we have in the inter-American system, really, to explore in a more deep way through our standards. So in relation to my mandate, we are really trying to keep the eyes in the right to nature and to explore the way to connect the right to nature as is considered in several constitutions in our region, for instance, the Ecuadorian Constitution or Bolivian Constitution, and how to connect this with the obligation regarding the inter-American system. So this is a real point for my mandate in trying to explore and to develop the standards in relation to environment. And in relation to the pandemic and the precautionary measures, yes, this is a huge worry for the Commission and for the mandate. And it's true that we are considering, the Commission is considering several precautionary measures that are related to the protection of environment and very especially in relation to indigenous people, as well the right to health, because I would like to take advantage of these question moments also to emphasize two ideas. And one of the ideas is the concept of indivisibility of rights. For the mandate, this is a crucial and central part of the cosmovision of the mandate. I think the system is evolving thanks to the creation of the special rapporteurship, for instance, to a new way to look at, to protect and to promote human rights. And it's not just a way based and concentrated in the civil and political rights, but also, and I can say mainly at this moment of pandemic sanitary crisis in economic, social, cultural, and environmental rights. So I think we are in a new era that also the jurisprudence of the court, of the Inter-American Court, especially if we regard the Lagos del Campo case, and of course the 23 advisory opinion, we are living a new moment in the inter-American system. And this is very important, very good, I think. And we need also to continue pushing the system in this way of the indivisibility of the rights and the interdependency of all the rights, human rights. And in the same, in my second idea or second point of information, because I forgot to mention a very important tool for also defending climate change in relation to the fight against climate change in the Inter-American system. That is the new report of the special mandate in my chart that is about business and human rights. And I think this is a very important milestone also for the system, because we are talking about the first thematic report that is arising the question of business and human rights from an Inter-American perspective. And in this report, we try to systematize all the jurisprudence standards, also the state's obligation. And I think in that sense that the point that Monica pointed out about the importance to combine the analysis of the actions in relation to states, but also in relation to business sectors, of course, and other non-state actors. In this sense, I would like to invite all the audience to consult and read this report. We are just finalizing the English translation, and we launched this report early this year, and it has been also in a very, very collaborative process, and a very active process from the civil society with public hearings. So I think it's a very important tool for the climate litigation too. And we have, for the first time, I think, in the history of the system, a particular chapter related to climate change. And in the criteria, Inter-American criteria, because this is a report, of course, related with the UN development in the area, but it's beyond that because it's an Inter-American report, the first one. So I think it's important also to point out that the criteria, Inter-American criteria we have developed in the report are related also with environmental rights and with the centrality of the victims. And also with another aspect that is crucial in relation to environment, and I really agree also with the appreciation of Monica about this is and no boundaries issue. So is the concept of extraterritoriality. Is the first time after the 23 advisory opinion that this is in an Inter-American report as the business report and human rights report. So thank you very much again for the opportunity. And I decided to speak in English finally a bit, even if I am very tired. I think that will be better for Danielle. Thank you again, Danielle. I know I spoke very, very fast and you suffer a bit. And I also would like to thank Daniel, not just because he's an extraordinary translator, but because he's also part of my team, as part of the global network, and he's doing a very, very important job in the special rapporteurship. So thank you very much, and please keep in touch and keep fighting together for environmental rights. Thank you.
Thank you. Thank you very much, Soledad. So there's one question for Astrid. Given that you mentioned how the law follows rather than leads, and how can lawyers help build social solidarity to prevent the need to resort to laws?
Thank you, Maria Antonia. That's very complex question that maybe it's enough for another webinar, but I think that and at least from my experience and what we do in AIDA is make sure that we remember that we are a piece of the puzzle and we are not the end of the way. And so the again, from our experience, what we do with the legal actions is that we coordinate the legal actions, the strategies, what is that we're going to ask, what happens if we win, what are the risks if we don't, what are the advancements with the community and the people that we represent. And I think that that's a key element, because you can't imagine, or maybe you do, the amount of things that we have learned. And that is how we can help the lawyers are at the service, and thinking about what I said in the presentation, that justice and climate justice should be the goal. So that's one thing. Just having our feet in the ground, if I may say as well. And remember, because sometimes in this society, we are so compartmentalized. And at the end, it's also about our planet, our climate, our rights. There are some communities that might be more in the front lines or directly impacted. But I mean, I live in Mexico City, where the air quality, and it's the same in all of the Mexico City, in Latin American cities, is really bad, and it's getting worse because of climate. So remembering that also, and so just making sure that it is a strategy that is not legal only, but it's linked to science and to other elements. Because, I mean, as it was mentioned, it's not only about this region or this other region, these strategies are interlinked because we only have one planet. There's other people that are thinking about other planets and conquering other planets. I think that the better idea is just to save this one for now. So just thinking that we are, and making sure that we are part of the puzzle, and that we, in the legal work, from lawyers or judges, etc., are thinking about what is going to happen with X decision, law, or jurisprudence that we get.
Thank you very much. And then one last question for Monica. How can we overcome the challenge of providing evidence on climate change and climate litigation, and broaden the range of stakeholders involved, especially private actors?
On evidence, is going to be very much depending on the type of case you have. I believe that we are talking about international law or an international case. The science is very clear nowadays. It has advanced a lot. In the past, causation was a major hurdle when it came to evidence. But now I think things are a little bit clearer. However, I think evidence is key in this type of cases, even if we are going to an international court, because you are going to have to prove that what you are saying is breaching that treaty. It has to be attributable to a particular state you are bringing the case against. And that means that issues of attribution have to be clearly addressed in your supported by the evidence you are presenting. And this evidence can be as wide as reports by the state itself, but also it's quite important, the evidence from your victims or the people affected by that, photographic evidence, video evidence, expert evidence. So you have quite a wide range of possibilities. And that's the type of evidence you can bring in this type of cases. The second question was on private actors. And how can you bring more cases against them? Or sorry, what was the, yes?
Mm-hmm. Yes, yes, it's just.
Well, I mean, I think what I think is that the law is very malleable. And I think that this type of litigation really shows how malleable it is. And look at the example of the brilliant example of this case that was brought by this wonderful litigator in Germany in the Oberlandesgericht in Hamm concerning a situation that is happening in Peru, completely, and it is against a private company. It's an example that worked well in Germany, let's say. But even a very conservative administrative court is taking up the case, is looking at the civil law. And I think that what is important is not to be so fixated about one way of doing things. Quite a lot will depend on the type of advice that one can get. So try to get advice from people that have the experience in working in these cases, because there is already an accumulated knowledge when it comes to you know, what works. And then a client, you know, a lay client or the communities affected by that can make decisions as to what may be the best case for them according to the type of remedies that you may get. And that's something that has to be taken into account when you decide course of action.
Perfect. Thank you very much. And with that, we close our panel today. I wanted to thank you very much, all of our speakers, Soledad, Juan, Astrid, and Monica. It was really wonderful and very insightful. Thank you for your availability to come here and discuss all of those issues with us. It was really very broad in terms of the issues that we covered. There's a lot out there, and I'm sure we will need more webinars to go into a little more detail, but we really appreciate you coming here. And thank you for all the participants for the engaging questions as well. Just wanted to remind you that on September 1st, we will have our next webinar and continue our journey throughout with climate litigation throughout the world, and we'll move to Europe then. So I hope you can all join us there as well. So thank you very much, and hope to see you all soon.